I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my born-to-be co-host, Brett.
I was, Alice. This is what I was born to do. Do this podcast with you. There's no other purpose in life that I have but that.
It's like your
My children are
birthright.
ancillary. My job is really this. This is my destiny.
This is your birthright, some might say.
Birthright. There you go.
You were born in the
it.
midst of podcasts materials.
It's true. It's true. It's a good point.
Oh, my goodness. Well, guys, we may seem a little loopy, and certainly we are not, because you guys know how much we love every season of SCOTUS, the Supreme Court. And here we are, just days after the arguments were done at the Supreme Court about the birthright citizenship question that we previously covered on the merits. There's no opinion yet, but a lot came out in the arguments, in the questioning. There's a lot of articles out there saying, X, Y, or Z. It's going to be split this way, that way. So we thought we'd break down what happened at the arguments for you. And we are in May of the Supreme Court term, meaning that we're about a month and a half away from the Supreme Court finishing its term, coming out with all the decisions. So there will be an answer sooner rather than later. But we thought we'd jump in, fool's errand, right? To tell you what we think will happen.
I think this was actually the last argument of the term. So it's going to be all decisions from here on out. I'm sure we'll be doing some legal briefs on some of the decisions, depending on what they are and how interesting they are. But yeah, so birthright citizenship, we covered it in a couple episodes and the sort of constitutional basis for it, the arguments for and against it, all that good stuff. And the issue has been sort of winding its way through the courts, but in the process of doing so, something happened that has happened in a lot of cases during a lot of presidencies. There was an injunction by a district court saying that the executive order issued by President Trump purporting to end birthright citizenship for certain people could not be enforced.
Now, a lot of you who've been listening to Prosecutors University, all our different podcasts for a long time, probably might be asking, wait a second, I thought judges had their certain jurisdictions and they only really can order things within their jurisdiction, right? Like if you have a state jurisdiction, they can only order things happening within their jurisdiction. So how can one judge, a district court judge who's sitting in some district somewhere in the federal circuit, tell the government how they can or cannot apply something across the nation? Well, you're correct. This is exactly the question that actually has been debated long before this particular case. And because of its effect of being applied across all jurisdictions, we actually call it nationwide injunction instead of just injunction, because as you can tell, it has effect far beyond that particular judge's jurisdiction. And there's a major question of, can a judge do that? What are the effects of that? Does that give one judge too much power to be able to control, what can be applied to other jurisdictions, other states, for example? But one thing I do want to note, if you're new to this legal, it's not a phenomenon because it's happened for a long time, is that, when I worked for the government, I actually litigated nationwide injunctions on the defensive. So the government would get enjoined, just like in this case, in multiple, 3, 4, how many different administrations?
When did you start at DOJ?
The Obama administration. So on both sides of the aisle.
What year?
2014.
That's interesting. So when I was trying to get these nationwide injunctions, I
was defending them. So I was literally the office that defended all of these nationwide injunctions. We were probably opposite each other in a lot of these cases. A lot of the Texas cases, for example. Yeah. And I state this because it's easy to turn these types of questions, especially when it has to do with executive orders, something like birthright citizenship that seems like, a very big policy question, into just a purely political question. And this is something that is used, that has been an issue and part of discussion in multiple administrations, whether Republicans or Democrats. And now it's percolated, of course, up to the Supreme Court, as many of these questions do. But it is not a new question, and it is not the first time a nationwide injunction has been issued either.
And so we've seen this more and more sort of unique strategies in various branches of government to either stop or move forward an issue. And you've seen it a lot. I mean, it's kind of funny if you think about it. There was some argument at the Supreme Court about when these universal, which is what, so you can call them a nationwide injunction or universal injunction. I think universal injunction is a little bit more pejorative, whereas nationwide injunction maybe is not so much. Just people use different terms when they're talking about it. But there was this question about when these started. And one side argued, I think the Trump administration argued, that the first one was in the 60s, civil rights era, that type of thing. The other side tried to push it back a little bit further into sort of the early 20th century. But I think everyone agrees that for the first 120 or so years of the sort of nation, you didn't see these. You really didn't see these type of things. Now, one of the reasons you're seeing more of them is because some other tools that weren't used as often are now being used more. So executive orders, for instance. If you look at the number of executive orders issued by various administrations, it has been on the rise for the last 40 years or so. In addition, the use of the filibuster in the Senate has been on the rise. Filibuster used to be a relatively rare thing. There was a lot more sort of bipartisan cooperation, bipartisan agreement, willingness to allow certain bills to go forward for other considerations. A lot more horse trading was sort of allowed 40 years ago than you see now. So you see more filibuster in Congress, fewer significant pieces of legislation passing, more executive orders being issued by presidents, which are automatically on a weaker foundation than a law passed by Congress, signed into law by the president. And you started to see a lot more legal organizations becoming much more savvy about the way they used lawsuits. So as Alice was saying, back 2014, 2015, 2016, I was working for the state of Alabama in the Solicitor General's office. Alice was in DOJ, and we would file these lawsuits all the time, or would support these lawsuits in other states. Alice mentioned Texas on various issues. So we did a lot of work on the Endangered Species Act. There was also a lot of work on the waters of the United States, or the Clean Power Plan, or various other sort of executive initiatives that intended to do something that the states felt would harm the state's interest or harm business in the states or whatever. And so we would seek these nationwide injunctions. And Texas was a good place to go because there were a lot of single judge districts where we knew what would happen, right? I mean, you see in the press, they'll act like some neutral magistrate is considering these issues and issuing an injunction. But we all know the score here. You go where you're going to find somebody who's well known to enjoin everything. There are a couple judges in Texas who, if you're a president with a D next to your name, we're getting the injunction, and it's going to be nationwide. There are several judges in places like Oregon and Hawaii who, if it's Donald Trump, you're getting the injunction, right? So that's where you go and file these things, and you're fighting them out both in the district court and then up to the appellate court and ultimately in the Supreme Court. Often something else you're seeing more of, which we talked about with Judge McFadden way back in legal briefs, the emergency docket, the shadow docket, whatever you want to call it. Why do you see more of that? Because you're seeing more of these types of actions that need to be dealt with fairly quickly by the Supreme Court because of their breadth and their scope.
And in this particular case, several cases were filed, and the government, this administration, was losing them. In other words, the courts across, I think at least three courts, were granting these universal injunctions. And so they sought cert on this question. And we've talked about this before, that you can seek cert, but the court is one of discretionary jurisdiction. They don't have to take every single question that comes before them. But they chose to hear this argument, a month ago, which is very, very fast. Usually they fill up their entire argument schedule. And in fact, I'm pretty sure this is being argued outside of their normal time, if I'm correct, because they're usually working on all of their opinions to be able to be finished in June. And so they slotted this in, which typically, if you're accepting a case for argument in April, say, you can easily push it to the next term, the next season of SCOTUS, right? You can easily set it for argument in October. In fact, most cases, that's what happens, to be able to properly administer all the things you have going on. But in this case, at least it indicates that it's a question with some urgency that the court, the justices, wanted to deal with before the fall, which there may be one example that we'll talk about right now is chaos, right? People don't know how to apply the law. What's the law? And there are real facts because obviously people are being born between now and the fall and whenever the opinion comes out. And so this is one of those questions that you won't typically see it speed through the Supreme Court so quickly, but I think you can imagine why in this particular case the court did want to slot it in this term before they left for the summer so that we will have an opinion really within the next month.
Now, what's interesting about nationwide injunctions is it's kind of like the filibuster. So whichever side isn't in power, so in the case of filibuster, whichever party isn't in power loves the filibuster. I guess it goes, okay, it's the same for both. So whoever's in power hates the filibuster and hates nationwide injunctions. Whoever's out of power loves the filibuster and loves nationwide injunctions because they can use it to stop things, right? And the people in power are like, why are you doing this? We have a mandate from the people. We won the election. We should be able to legislate and to take actions or whatever. And so you see it sort of swing back and forth. Now, people on the right, the Trump administration, are very much, we need to get rid of these nationwide injunctions that are holding back President Trump. But they're the same lawyers arguing that are the ones who were filing for them 3 years ago, right? Because that's just the way it goes. And it's the same thing with the filibuster. The Republicans are now in control of the Senate. So I am certain you will hear weeping and gnashing of teeth on the right when various of President Trump's initiatives die because of the filibuster. But 3 years ago, the Democrats were trying to get rid of the filibuster, and it was this huge deal that a few Democrats said, no, we're not going to do that, right? Because we're so short-sighted in politics these days, you don't really understand. So you're seeing that sort of play out. But this is the first time that the issue has really gotten to the Supreme Court. And it got to it on the back of this birthright citizenship issue. Now, typically, when the Supreme Court considers the scope or legality of a preliminary injunction, which is what you have here. So Joe in the chat asked that, what's the difference between a temporary restraining order and a preliminary injunction? So the way it works, so let's say President Trump issued an executive order right now to kill all the turkeys. I don't know why. He hates turkeys. So he's going to kill all the turkeys, right? And it's happening by midnight. He's given like an order. You got 3 hours to say your goodbyes, turkey farmers. You're all getting killed. They're having Thanksgiving for the next week. Anyway, and the turkey farmer's like, no, we don't want that to happen, or PETA or whoever. Well, the first thing they would do is they would file for a temporary restraining order, which basically would say, hey, there's this issue coming up. It's an emergency. It's, we got 3 hours to comply. Put a TRO, a temporary restraining order, on this to stop it while we can brief a preliminary injunction, which is a sort of bigger, more in-depth thing, and then eventually seek a permanent injunction saying you can never do what you're wanting to do. And so you're seeing these sorts of actions filed in the courts on various things that the executive is trying to do.
So just to show you that a TRO, temporary restraining order, and preliminary injunction, PI, that then gets converted into a permanent injunction if you win there. These are not just things for like these big policy questions or political questions. These are actually very conventional uses you'll see all the time in civil court. I'll give you an example that may affect you. So let's say you're renting an apartment and you have a lease with your landlord, and your landlord alleges that you violated the lease because you have a dog and you're going to be evicted. And let's say you don't have a dog or there's some exception or whatever. You're like, no, you can't evict me. So you would go to the court and say, Judge, I am about to be evicted. I'm about to be homeless. He's going to kick me out because he thinks I violated the lease. You need to put a TRO in place while I show you all the full merits of my case, why I shouldn't be evicted today. And if you're able to show certain things and it's on an emergent basis, basically you have to show certain things like it's irreparable harm. It cannot be healed later on, right? Once you're evicted and homeless, that's hard to make you whole again. It's not just say money, for example. So if you can show the judge that, you basically, in some situations, you can get a TRO within like 24 hours, 12 hours, 48 hours, a very, very short amount of time. You see how long these legal cases take. So it's much shorter than a typical case will take. And you also sometimes don't even have to hear from the other side in certain emergent cases. Ships leaving shipyards, for example, those are classic examples of TROs. So that's when you run to the court because there's some irreparable harm and they need to act immediately But then as soon as you get that TRO, let's say you get it, the court says, yeah, that you look like you're going to be irreparably harmed. You're likely to succeed on the merits based on what I've seen so far, but we haven't had a chance to develop the record. Then you go back once you've gotten like holding the status quo. That's what a TRO is. Status quo, nothing changes. Like suspend everything while we deal with the actual merits of the question. And then you brief and argue in kind of a more thorough pace for a preliminary injunction, but the TRO cannot last very long. I think in most jurisdictions it lasts something like 14 days, usually about a couple weeks, because it's not meant to be long term. It's just meant to suspend the harm so that we can show you, judge, why you should grant us an injunction.
This episode is brought to you by Progressive Insurance. You chose to hit play on this podcast today. Smart choice. Progressive loves to help people make smart choices. That's why they offer a tool called AutoQuote Explorer that allows you to compare your Progressive car insurance quote with rates from other companies. So you save time on the research and can enjoy savings when you choose the best rate for you.
Give it a try after this episode at Progressive.com. Progressive Casualty Insurance Company and Affiliates not available in all stages situations. Prices vary based on how you buy.
And ordinarily, honestly, maybe not ordinarily, but I think it is typically the case that the other side doesn't even oppose a TRO. It's, unless it's really important to the other side to move right now. A lot of times they'll say, we want to oppose the temporary restraining order to give everybody an opportunity to brief it, unless it's frivolous, right? Like there are frivolous temporary restraining orders, and you see that every now and then. But, so that's what you see happening, and you're seeing that in a lot of these cases recently. Now, Alice touched on this before. So what's the issue here? Why is this a problem? Okay, well, there's a few different arguments that came up in this case. So basically, you have this nationwide injunction, and the administration, in sort of an interesting twist, they only appealed the nationwide injunction part. They didn't appeal the merits. This was discussed extensively in Supreme Court, because typically when you have an injunction and you go up to the Supreme Court, yeah, it's about the injunction. It's really about the merits, because a key part of an injunction consideration is whether or not you are likely to succeed on the merits. So you end up arguing the merits, and then the Supreme Court either says you're likely to succeed or you're not. If they say you're likely to succeed, that's basically the end of the litigation, right? I mean, unless you really think you can overcome that. If the Supreme Court's already said you're likely to succeed, guess what? You're going to lose, right? So you might as well just let that go. But in this case, the administration did this interesting thing where they only asked on the issue of nationwide injunctions. Now, why are they doing that? Don't they really care about birthright citizenship? Well, yeah, they do. But as you're probably aware, there have been a lot of nationwide injunctions in the last 100 days on various things the administration has done. And it has become a priority for the administration to end these nationwide injunctions so that they can move forward with their priorities. The thing about it, as Alice said, under our structure of government, Article 3, typically a judge has authority over the parties in front of them, and they can grant relief to those parties. So if Alice sues the president, the judge typically can give relief to her. If she is in a class, let's say she has a class of all the people like Alice, which would be a class of one because Alice is unique. If she has that, though, then it can bind everyone in the class. And, it can be a little bit more extensive. Like you're a district judge. Let's say you're in the Middle District of Georgia and you issue an opinion. It's not binding on the other judges in that district, but usually it's sort of an act of judicial comedy. The rest of the judges, unless they think you're completely crazy, are going to go along with that, right? And then when it goes up to the 11th Circuit makes a decision, and it's going to bind everybody in the 11th Circuit, even if it's only one or two parties. And then it goes up to the Supreme Court, and it's going to bind everybody in the country, even if it's only one or two parties. This, though, as part of a district court's ability in equity, essentially, to give full relief, you have judges saying the only way to give full relief to the parties is to issue a nationwide injunction. And someone in the chat asked, aren't there rules about this? Well, there are, and typically you should only do that if it is necessary to give full relief to the parties. And the Supreme Court has reiterated that on multiple occasions. What you have here, and why this has been interesting, is if you're someone who is saying, look, I fall under the four corners of this, but I'm about to have a child, right? Because it's forward-looking, not backward-looking. So imagine it's someone who's pregnant, about to have a child, and under this executive order, that child won't be a citizen. I'm asking for you to enjoin the order. Really, if I enjoin that as to you, you have full relief, right? So making it nationwide has to be for some other reason. And what the district judges would say is you need uniformity in this rule, right? So we can't have your child is now a citizen, but, Bob down the street, his wife's about to have a child. She's not party to this lawsuit. She's not going to be a citizen, right? And then you have states who are also suing, and they're like, hey, this is a big deal for us, because if only the people who are parties to the suit get relief, how do we manage that? How do we decide whether they get Medicare benefits or Medicaid benefits?
It's a massive administrability problem, right? That's what the states argued here. They said, I think New Jersey's Solicitor General said we have 6,000 births out of state a year. You can imagine we've laughed about this, where Texans, sometimes ship Texas soil to another state and have a baby with Texas soil under them so they can have Texas babies, right? That's kind of a joke, except we know that people do have babies outside of the states. And so what do they do if they have these 6,000 births a year where they have to determine who is a citizen, who is not, when in the past there were pretty simple ways that they could tell whether someone was actually a citizen. If they had a social security card, for example, that was issued at birth, that was a good indication. But now basically these states had to figure out for themselves a huge administrative nightmare of how to allocate money for schools, for services, for Medicaid, these sorts of issues. And also there's obviously this very unfairness. You could literally be born across the border from your state, and maybe one state has birthright citizenship and the other one doesn't. Now, this clearly, we are free to travel across the nation, right? We are one nation. We are one united nation with all these states. These states are not countries in and of themselves. It turns into kind of a logistical nightmare. What do you need? Some sort of a passport to go from one state to the next? These are all questions that were being brought up during oral argument. And you can see why the states specifically were arguing that the only way to apply this was to apply it to the entire nation, to have it be universally applied, and not just to, say, Alice, who was about to have a baby, that my baby was going to be a citizen under this EO, but nobody else's.
And if you listen to the argument, it was very evident that the court does not want to decide this issue, at least in this case. And people on both sides, we all know how the Supreme Court breaks down, right? So you've got Justice Kagan, Justice Sotomayor
Jackson,
Justice Brown Jackson. They're on sort of the left side of the court. On the right side of the court, you've got Justice Thomas, Justice Alito, and usually Justice Gorsuch. And then in the middle, you've got Kavanaugh, Barrett, and the Chief Justice. And the Chief Justice, at least the Chief Justice, Sotomayor, and Kagan, all were like, isn't the easiest way for us to deal with this just to decide the merits? Can we just decide the merits? And that way we won't have to worry about this issue of some people having citizenship, some people not. Why don't we just decide the merits? And you would think, as the administration, you'd be like, yeah, let's do that. Let's skip all this stuff. You're telling me you'll give me cert right now and we can decide this issue once and for all? Absolutely. Sign me up. When do you want the brief, Judge? Right? But they didn't do that. They were like, no. This needs to percolate more. Like,
right. Which is typically what you do, right? Which is percolate. And so Kagan puts her finger on it, which is why this is happening. And lawyers by the way, I've heard a lot of headlines that are like, this is strategery. They're playing gamesmanship in what they're appealing. That is absolutely strategy in terms of your legal arguments. All lawyers do this. You decide which parts to appeal and what not to appeal. But Kagan kind of pummels John Sauer, the U.S. Solicitor General, saying no, the reason you're not appealing the question is because this lawsuit has been brought against you in a bunch of jurisdictions and you keep losing. Typically, you go up on the merits because there's a split or something. Right now, the courts are building against you. There's a lot of these nationwide injunctions, these universal injunctions. And she says the reason you don't want to appeal the merits is because if it gets here, you don't want us to take it because you're just going to lose because you've been losing this whole way and it's going to come up here. Now, whether that's true or not, Kagan is one justice of the 9 justices, but you can see why that argument would percolate in this situation because they aren't actually reaching the merits. And in fact, when offered, you want us to reach the merits? The government says, no. Now, Brett, you're chomping at the bit. There are reasons for this because this is the one. Look, we've said the court takes 80-ish questions a year. There are more than 80 nationwide injunctions pending right now, this administration. So you can imagine that one case could potentially have huge ramifications on many other cases that there literally is not enough time to argue all of them at the Supreme Court right now. So they have a case for it in order to argue. And so from strategic points of view, when you only have a couple cases in which you can bring before the court, you want to win for all your cases. And with so many pending universal injunctions, you can understand why strategically you want to appeal on this type of question. I wouldn't say that's gamesmanship. This is honestly what lawyers do in every type of case, a civil type of case, a criminal type of case. You look for the best win for holistically what's happening, right? And so that's one thing to keep in mind here is that while we are up here on the birthright citizenship question, nationwide injunctions has been an issue and continues to be an issue for every administration who's used executive orders, which is all the recent administrations, in order to basically effectuate what they campaigned on.
And it's fascinating because, and Alice is right, and we talk about this sometimes, in the Supreme Court, your goals are different. In the district court, it's one person trying to win, and the district court really cares about the litigant in front of them. And then when you get to the circuit court cares about the litigant, but they also care a lot about the states beneath them and the rule that's going to now apply in their circuit. Supreme Court doesn't care about the litigant at all. It's all about the rule for the nation. And this is sort of a twist on that. The administration cares about birthright citizenship, obviously, but they care a lot more about resolving this question. And I mean, it is kind of gamesmanship when they say, oh no, we want this issue to percolate. We want it to be considered in local. I mean, what are you talking about? You're not going to win in any of those courts.
Can we address that real quick, though? Because
Sure.
I do think this is helpful to address. A lot of people are thinking, how does that help them to percolate? Or how does it help them to not overturn a judge ruling against them in lots of cases and just getting rid of the nationwide part? Here's why. Kind of what we talked about earlier with judges all over the country, and especially in these like more rural districts where you have one judge, you know exactly how that judge is going to come out. Even though they basically, have they lost every single case? I think they have. Because the plaintiffs know where to, yes. Yeah. Because the plaintiffs know where to bring the case. That's why they are losing everywhere. There are districts, probably about half of them, that they would not lose. And so there would, in effect, not be a universal injunction. It would honestly be probably more like circuit by circuit, how this is applied. That's a greater win than just losing across the board, especially if what you mean by percolating is things can come in the interim. Maybe there's going to be some legislative action or constitution, other things like that. So there are things that are percolating, and that's why it is actually a win if they are able to apply to only some jurisdictions, because the reason they're losing in every jurisdiction is because they are strategically brought in these jurisdictions. There are other jurisdictions as well.
So I hate to disagree with you because
No, you'll disagree. Go ahead. You disagree all day long.
I agree. I would agree with you on almost any other issue. I think they're going to lose everywhere on this one. I think if they only cared about this issue, they would fall all over themselves to have the Supreme Court decide, because I think they need the Supreme Court to issue an opinion sort of basically taking the position that we talked about in the birthright citizenship thing, that Wong Kim Ark isn't actually about what people say it's about, right? I think you really need that. Is it possible they could draw in the Fifth Circuit, maybe, the right group of people and win? Possible. But I really think they'd have to get pretty lucky even there.
I think in the interim, they're able to enforce it scattershot, and there will be confusion. That's not that I think that they're going to bring this lawsuit in order to try and win and create a split and then argue to the Supreme Court. So that's what I mean, is they would prefer a scattershot while things are unsettled to shore up whatever arguments they have. Not that they would actually try and go win in a jurisdiction. I don't think they'll do that.
And Justice Kagan puts her finger on this. You mentioned Justice Kagan, because she points out if you got rid of nationwide injunctions, then you would never want it to go to the Supreme Court. Because basically you would be in a situation where unless someone hired a lawyer and sued on their own, they could not get relief. They couldn't get relief from someone else's lawsuit. They would have to sue themselves or join another lawsuit. And that was one of the things she brought up. Like, why would you ever want it to come before us? Because you can do what you were saying. You sort of can enforce it generally, and maybe you're losing some cases here and there, but it really is insignificant in sort of the grand scheme of things. Now, there was an easy out. And this is getting a little in the weeds, but it's worth getting in the weeds because I was fascinated by this. So Jason Blair said, is this the worst possible case to use to go after nationwide injunctions? And on the one hand, it is, because the issue is clear, straightforward, affects every state. You need uniformity. Like, there's all sorts of reasons to say, if you were ever going to go after a nationwide injunction, you really want like a fact pattern that's better. Like, why do you have a nationwide injunction against deportations, for instance, when deportations are very fact specific, right? Like, sometimes you can deport people, sometimes you can't. So having a nationwide injunction is weird, right? That's a good one to attack. But this seems strange. But the thing is, you have an out, because what the administration could have said is, it's easy. This is also the perfect case for a class action, because you have numerosity, it's a straightforward legal question, it's uniformity, commonality amongst the class, because it's basically, if you're here under one of these categories, you're part of the class, right? So very easy to certify a class, and you can just have a class of everyone affected. So then you don't have a nationwide injunction, you just have a really big class. And this out was sort of offered multiple times by various justices to the administration, and they just refused to take it. They said things like, oh yeah, class certification. Yeah, absolutely. Yeah, we think, yeah, class, that'd be great. And they'd be like, okay, so you agree a class would be appropriate. Well, no, we would oppose class certification. It's like, like, you need to be able to say, just strategically, yes. The reason nationwide injunctions, you shouldn't have one here, is because this is the perfect case for a class action, and they skipped all that. They skipped the rigors of class action to go straight to nationwide injunction, and you need to do something about that, because there's an easy answer that solves all your problems and addresses all your concerns and solves the problem of nationwide injunctions. But they wouldn't take it.
They wouldn't take it. And the reason you should take it is because there's like an entire process of getting a class certified, right? Like, you don't just decide you're a class and all of a sudden you're a class. You have to go through class certification, and it's like a mini trial on whether you have all the factors that allow for a class to be certified in order to bring the case. So like, it's almost like kick the can down the road is what the justices were trying to do, right? They were trying to give them an out, and they did. They kept talking. They would go right up to the line of, yes, absolutely, the class would bind everyone, and then, if you fail, you can come back again and try again. But then when asked directly the question, they were like, nope, oppose. And here's the problem. I think they had to, because there were certain lines they probably couldn't take, because if in fact it came out as the court shy of saying nationwide injunctions, universal injunctions can't take place, if they said something specific to this case, like, this is more appropriate for a class, guess what the government has to do? They have to oppose classes, right? And so they can't bind themselves, because you need to know what you concede. You have to have the long game in mind. And if you concede your case away whenever you're arguing, like, you could potentially just lose everything down the line. And so that doesn't actually help them. And so this is where you have to think strategically long term. And I'm sure this came up in moots while they were preparing for it. Like, what do you have to say about this? And there were certain lines that they could not concede. And I think this was probably one of them.
The problem with that is, you can't walk into the Supreme Court and say, hey, Supreme Court, there's this tool that judges have used since the Civil Rights Act to deal with blatantly illegal things that affect large number of people. And we don't like the way they're abusing it, so get rid of it, right? Get rid of it. I want you to get rid of it. And the Supreme Court's like, okay, we buy your argument, but there's an equitable problem there. How are we going to deal with the consequences? Because the Supreme Court cares about consequences, right? It's not pure law. You have to be able to say, don't worry about the consequences, because X, Y, and Z is going to take care of that. Even if there's going to be some issues. I mean, think about Chevron, right? When Chevron deference came up, there were all sorts of concerns about Chevron. And the arguments on the other side were all these reasons why your concerns are overblown, right? Or presidential immunity, which John Sauer, who's now the Solicitor General, argued as a private attorney for President Trump and won. And one of the arguments was, look, people act like this means the president's going to be executing people. And no, that's not what's going to be happening for X, Y, and Z reason, right? I mean, they didn't just say, absolutely, Your Honor. It could be killing people left and right, but that's his right on the Constitution, right? No, they didn't say that. They explained why that wasn't concerned. And I feel like you really need to be able to say nationwide injunctions are an affront to the Constitution. They're being abused. Get rid of them. But this is the fallback to prevent the bad consequences. And they never really got there. And in fact, they even were pushing back on sort of comedy principles. So, for instance, this came up. Justice Kagan, who I thought was great in this argument, by the way. Justice Kagan was like, okay, let's say it goes up to the Second Circuit. You got a few plaintiffs. It goes up to the Second Circuit, because that's one of the cases in the Second Circuit. And the Second Circuit says, you lose. Do you commit to not enforcing this in the Second Circuit? And the Solicitor General was like, well, that's generally our practice.
Oh my goodness.
Yeah.
That's
And
unfortunately
Justice
going to have to
Kagan,
be like a shirt.
who has been the Solicitor General
Of the
is
United
like,
States.
I know it's your general practice. I'm asking you whether they'll do it here. And he sort of hemmed and hawed on it. And then later on, and this is when you know you got a problem. Because I just told you the 3 camps, right? And you got to get 5, which means you got to get your 3 and 2 others.
2 others in the middle,
Right?
probably.
So then Justice Barrett comes back, who you may recall is in the middle. And Justice Barrett's like, I just want to go back to something you said earlier. Am I getting this right that you're saying you're not going to honor the Second Circuit if they say this? And it's like, and he once again sort of tried to hem and haw and like make her feel better about it. But that's a situation where if Justice Barrett is leaning towards you, now she's thinking, I don't know about this. Like, is it really the case that it has to go to the Supreme Court every time to get any relief beyond the named plaintiffs? Is that really what we're saying? And you can see why, if you're asking for something, don't ask for everything, right? You can't ask for everything. You're already asking to get rid of nationwide injunctions. You can't say, we want to get rid of nationwide injunctions, and we're going to oppose class certification. And by the way, even if a circuit says it, that still only applies to litigants. You can see why they made the job or their own thing so much harder to accomplish by the things they were saying.
Yeah, that part of the exchange was, I got like very anxious for John Sauer, who was arguing. As soon as he said generally we would abide by the circuit's ruling, I was like, oh no, Kagan's going to jump all over this because she knows exactly what it's supposed to be. And why is this so problematic? Of course, there's, the separation of powers, and that's the way this is supposed to work, right? You're supposed to abide by the court's ruling until it's overturned. If it's overturned in the circuit courts, really, if you make it to the circuit court, that's usually where it ends because of the discretionary function of the Supreme Court. And they're saying, we don't have time to deal with all of this, nor is that we're not the only court. There are all these other courts who are supposed to be able to weigh in on these issues. This is part of the percolating thing. And this also cuts against the whole, we want it to percolate, but you're telling me if it percolates against you, you're not going to actually abide by it. This is going to create a complete judicial mess for us.
And look, I mean, like I said, I'm on both sides of this because I've loved nationwide injunctions and hated them, right? But I feel the power of the argument that it is beyond the scope of the Article 3 powers of a district judge, a judge with extremely limited jurisdiction, to ordinarily, unless it's an extreme case, enjoin an action nationwide. We talk about this a lot. Who is the person who thinks they're above the law, right? It all depends on what your politics are. So if you support the president and the president does something and this random judge in the Western District of, Arkansas or whatever says, no, Mr. President, here in Texarkana, we're going to say you can't do that at all, right? We are enjoining you nationwide. If you support the president, you're like, who does this guy think he is? Like, why does he think he's above the voters, above, the president? Why does he think he gets to decide what the president can and can't do? And then if you're on the other side, you say the president is not above the law. The president can't be a dictator. And if he does something like this, then we should have a district judge step in and say, no, you can't do that. And that's sort of like the highfalutin philosophical consideration here. But the thing about this argument, and what it really highlighted, I thought, were all the practical considerations. Like, the practical considerations really cut against the administration's argument, at least the way they argued this case. It made it feel like the practical consequences of getting rid of universal injunctions would just be so egregious and so difficult to manage and so hard on the judiciary and hard on the states and even hard on the administration that doing it would be a problem. And there's the issue of, why do you have to move so fast? What is the harm ordinarily of the court saying, we're going to have to decide this, we're going to have to consider these arguments before you start taking these really important actions that have a huge effect on the litigants before us and other people who are not before us? Like, why can't you wait a year for me to decide, and then the circuit to decide, and then the Supreme Court decide if that's what needs to happen? Like, why the rush? In the courts, there is this natural feeling that we don't want to rush. Courts never want to rush anything. They want to deliberate. They want to consider. That's why percolation is such a big thing. The Supreme Court likes it when learned judges of the Second Circuit and the 11th Circuit and the 5th Circuit and the 7th Circuit are all reaching different conclusions for different reasons. And you even see this in the argument where you had the various litigants citing to, well, Chief Judge Sutton said X, Y, and Z. And then the other person's like, well, this judge on the First Circuit made this point, because the more sort of intelligent, learned, smart people you have making your arguments, the more it sounds like you're taking a reasonable position. So ordinarily, that's exactly what you would want. So I think this whole notion of, no, we can't do that, we need to be able to move with speed, is another reason that I don't really feel like the Trump administration is going to win in this circumstance. I don't know what the outcome will be. I don't know how they will rule.
It is
on
going
it.
to be interesting because whatever opinion they write, they do have to get like a majority, And so this is, okay, how I've always told you, whenever courts are dealing with a meaty issue, especially the Supreme Court, because the Supreme Court's opinion is supreme, it's going to apply to all courts below it. They want to decide an issue as narrowly as possible. That's what they were trying to do in going to the class action, trying to basically slice and dice as thin as they can. It's going to be very interesting what they ultimately talk about. A lot may be in dicta, but I think there's going to get 5 to say something that's going to help the administration be able to effectuate this particular EO or all of its EOs. It did not look promising after the argument, a few days ago, 4 days ago.
I dig it.
You what? You dig it. So this is not a question I want before, like you said, I just don't know. This is not right. Let them percolate if they want. Deal with this in another situation. But I don't know that they can dig it. They already extended the argument schedule in order to argue this case. So clearly, it's not like this is a surprise what they were going to hear. Of course,
But why did they take it?
I don't know. That's the problem. I think they can't dig it at this point. If you haven't been around for our SCOTUS episodes, is deny improvidently granted.
Dismiss is improvidently
Dismiss
granted.
improvidently granted. So they're saying whoops, should not
Should have
heard
taken this
argument
one.
of this. Whoa, that was a slip of the pen. Did not mean to have this one argued. And really, honestly, is a way for them to just whoa, this is not ready for us to decide, or we don't want to decide it. It does not happen often, but it has happened every season, I think. So
I
far.
just feel like, is this an important issue that should be decided? Yes. You could, I guess.
And it's so rushed. This is, like you said,
It
the
is so
last
rushed.
argument. It's 2 weeks after they normally finish arguments. First of all, they have all their other blockbuster opinions that they're still working on. I can't even imagine the conference after the argument. Usually the justices, typically will get in a room and take initial votes or try to figure out where people are and decide who's going to write opinions or competing opinions to decide what the ultimate vote will be. Can you imagine? I don't think anything came out of that conference in terms of being able to sign opinions, for example, or maybe
After-
7 opinions are being written.
After the way the argument went, the administration should withdraw the EO and moot it.
Yeah, that's
And just
That's
say,
actually-
we'll be
that's
back
actually-
later to talk about this on a different issue. Because,
But if they were
best-
going to do that, then they should have made the certain concessions and get the win on the
should've.
nationwide injunction aspect.
That's the thing. I don't
You know what I
understand.
mean? They should
why.
know if the government was going to do that, because when things are going bad for you, right? Then you need to just go for the bigger win and lose this particular case, and that's fine. And they didn't do that. They were going to lose everything, and they conceded nothing.
But if you're only appealing the nationwide injunction part, which is what they did,
They did not.
why
appeal the
didn't you
merits.
go in ready to make those concessions? That's the thing. It's not
know.
like, well, it's fine because I went on the merits. They're going to lose the nationwide injunction thing, but it was really about the merits, right? This was all it was about. This was the vehicle they chose to challenge nationwide injunctions.
Or flip it no, this is not a great case for nationwide injunctions to overturn nationwide injunctions and just go in on the merits.
Just go
and
on the
then
merits.
withdraw the EO.
Exactly.
Because then at least
Or
you can
win
get
on
an
the
opinion.
merits and deal with
then you can
nationwide
get-
injunctions later.
Then you can get an opinion that's like, on the merits, you lose because of X, Y, and Z. However, because even in multiple cases in the last few years, Justice Thomas, I think, has been the most vocal in the Hawaii case, talking about his concerns of nationwide injunctions. And this is your time to be able to get something much stronger. And the rest of the court is willing, or at least a majority of the court's willing to go along with it because whatever, you've lost on the merits. And so nothing bad is going to happen. Basically, it's like splitting the baby, right? Don't worry about it. States, individuals, you're all winning. The executive order, dead, not going to work. Don't worry. Birthright citizenship, here to stay. So that it's more palatable when you say all these things about nationwide injunction that the government is actually arguing. But the way they argued today was they're going to lose the baby with the bathwater, I think. Like, if this continues, I think there's going to be very, very concerning language about the merits of the case, even though that's not what was appealed, because it goes so much towards why nationwide injunctions in this particular case. It's a tough case if this is the one you want to overturn it with.
So I think a few things could happen. I'm going to predict what's going to happen.
You think it's going to dig? I don't think it's going to dig.
I'm going to predict what's going to happen, and then I'm going to say what I would do if I was on the Supreme Court. So here's what I think's going to happen, and I think this is bad for the administration. I think what you're going to get is an opinion by Kavanaugh. I'm going to say it's by Kavanaugh, and it's going to be this sort of, no offense to Kavanaugh, but it's going to be this sort of mealy-mouthed, middle-of-the-road reinforcing of when you should have nationwide injunctions and how we have all these considerations and district judges really need to think about these things, and these are all the factors to consider, and we've said this before, and we want to reiterate it. Problem with that is, whether he says it or not, he's saying nationwide injunctions are fine as long as you follow these rules. So you've failed to kill nationwide injunctions. And guess what? The district court judges you think are abusing nationwide injunctions are not going to stop abusing nationwide injunctions because of that opinion. They're just going to say, we considered all the factors, and under those factors, clearly, we should be able to issue a nationwide injunction here.
Because I think that's exactly right. There's going to be more explanation. And so now instead of, we'll have to use the right language. Kind of like we were telling you about TROs, we have to use things like irreparable harm because that's the standard. We have to say likelihood of success on the merits because that's the standard. But what do those things actually mean? What is irreparable? That's subjective. That's not objective. What's likelihood? That's also subjective, not objective. And I think we'll get a lot of subjective, flowery dicta that will not actually change the needle in terms of how nationwide injunctions are applied by judges.
And then you'll get a concurrence from at least 3 justices saying, it is wonderful that today the Supreme Court reiterated that nationwide injunctions are perfectly legal, appropriate, and constitutional, right? And then you'll get a dissent probably from Justice Thomas and Alito and maybe Gorsuch saying nationwide injunctions are terrible, we should get rid of them, but hey, we lost. And those dissents and concurrences, even though the dissents and concurrences are really bad, because even the dissents saying we just reaffirm nationwide injunctions. So here's what I would do if I was on the Supreme Court and I wanted to get rid of nationwide injunctions. I would, despite what the administration said, push to go ahead and decide on the merits. I would hold this in abeyance. I would decide on the merits. And then once I decide on the merits, I would say, so this issue is now moot because we've decided on the merits. And I would let the issue of nationwide injunctions come back some other time. I think that if you are on the court and you want to limit nationwide injunctions or eliminate them altogether, you just need to go to the merits. That's your best bet. If you're not going to dig it, which you're probably not. And Justice Sotomayor and Kagan and the Chief already telegraphed in oral argument that they would be willing to do that, so hold them to it. Be like, hey, you guys said it. We're ready to decide it too. We don't need this to percolate. Let's go ahead and decide it.
So as to why, because the litigants are very bright attorneys. They are very good attorneys. Both, all the arguments were good. They were well briefed. Why only do a partial appeal? I think this is probably like client management as well, right? You have a client as well when you're the government. I think the question was probably the request probably was to appeal the actual merits. But in looking at what was happening and looking at the court, I think the attorneys were like, I don't think we want appeal the merits. But we do have this other issue that we do have certain justices who've written in past opinions, in dissents and concurrences, their concerns about nationwide injunctions. And that's what's really like, this is the issue, right? That's really affecting us and all our EOs and affecting our policy stances and whatnot. Let's appeal that. So maybe it was some sort of debate. That's why I think it's so like questionable of a strategy of the way it was appealed, of why it was that way. And there are a lot of things that happen for a variety of reasons, especially when you're talking about the administration, who has all its other EOs, for example, to think about, all its other policy concerns, all the courts that it's currently litigating in front of that they will be beholden to. Usually when you're just litigating one person for like one company, whatever, they're probably not in like every court in the country. The administration is actively litigating in every court in the country, I assume. There's probably not a single, there's probably not a single federal district court or appellate court that this administration is not litigating in. That's every administration, by the way. That's like why there are government attorneys, because there's a lot of litigation when you're part of the administration. So that is another consideration, is that it is a special litigant in the sense that there are active cases everywhere. Remember how we've talked about when you have an ongoing case, you tell your client not to speak because you're going to be held to like what you've said outside of court or, you know, publicly in another court in your active case. Multiply that by like thousands. That's what the administration is facing as well. This is just kind of to give you a view into the different types of litigation, why certain decisions may or may not be made. I don't know. I'm stressed out for them. I'm glad I'm not arguing.
Yeah. I mean, I don't have a whole lot more to say about the case itself. I think the question of nationwide injunctions is a really interesting one. But this was a fascinating argument for all the sort of behind-the-scenes reasons we've talked about and the strategy that went into it, the merits. I mean, it was really interesting, and it's worth listening to. I think you will enjoy it. It will be confusing to you to a certain extent, but hopefully now that we've talked about this, if you do listen to the argument, you'll get it more. You'll understand. Like when I keep talking about Rule 23, it's class actions, right? You'll understand sort of what they're
You'll
getting
understand
at,
why
so.
the Birthright Citizenship Supreme Court argument really didn't talk about birthright citizenship. 'Cause
Right.
I know that. Like, it didn't. It was about basically procedure and like judicial functions within the different ways of enjoining actions, rather than like our other legal briefs episode was about like the merits of the case, and that really wasn't brought here.
Yeah, and who knows if they ever will consider the merits now, because we're just
It was
going to,
like
I don't know, we're going to have to see what happens. I mean,
It was like half argued, right? And that's what's so weird, because typically when you have like the merits question, you have full briefing and whatnot. And this was like, it was in the shadow of everything. So it was kind of argued, but it wasn't argued, not in the typical fashion.
yeah, exactly.
Anyways.
It was weird. It was a weird one. So,
Wow. This really does. That does wrap up this season of SCOTUS. We
It does.
still have
Well,
lots of
until
we
the
have lots of
opinions
opinions to come out. I was gonna say we have lots of opinions, but in terms of arguments, there we go.
yeah, it's the end of the argument. So now it's
Whew.
just opinion watch.
Yeah. Well, people are dropping like flies because they're like, "What are you guys talking about?" This was just us nerding out.
It was. It's true.
Wow, it was somewhat confusing. I hope you got something out of this. And like we said, these Supreme Court oral arguments are available online. You can listen to them. I think it's very much worth listening to. It's only audio. It's not video, because video cameras are not allowed in the Supreme Court. And I don't know, over time, you get to like know all of the justices' voices, and you get to be part of the group of people who can be like, that was Justice Kagan. And you truly get to know, you know, what concerns them, because they truly, in their questioning, this is not like the Socratic method. There is a point in their questioning. Usually they're either trying to get a point across, or they have a real question about how they're going to write this opinion, and a lot can be clarified or confused, as is the case here, throughout the questioning. So this was an exciting argument, and we'd love to hear your thoughts. And really, the thing is, we don't have to wait very long. We're going to know what's going to happen in about a month, so we will obviously give you an update when that happens, and I'm sure lots of other blockbuster opinions that come out for the end of the season finale. Brett, is there anything else you'd like to... I guess we could do a question at this point, because we've lost so many people.
Let's do
We'll
a
end with
question.
something not so legal.
Let's see. I've already answered that question. Somebody asked, what's the absolute worst meal you've ever had in your life? I've already done that one.
That was a great
Only
one.
whale.
That was a good question. Who knew that would be such
Only
a
whale.
good...
Whale.
Only whale.
Claire says, when Auburn beats y'all in the Iron Bowl this year, I would appreciate a hearty War Eagle shout out. Well, Claire, if that ever happens again, then we'll see.
A hearty war eagle. It's okay, guys. I may or may not try to get under Brett's skin sometimes just by buying his kids Auburn clothes.
And it's always good to have kindling in the winter. something, roll up underneath the logs, light on fire. Let's
Mrs. Brett is just
see.
smart to kick it right back.
So, Chick Joan wants to know, what is the coolest job you can use a JD for?
Really
Coolest
anything.
job. You can do pretty much anything. So I'm trying to think.
JD, it's a terminal degree, and so a lot of people are able to use it to do things that you otherwise wouldn't be able to, like teach. Usually you need a PhD to teach at the collegiate level, but you can I think you can teach with a JD, or at least you can get tenure, something like that. You have to write a lot. But when I was in law school, I remember thinking one of the coolest things was that you could be like an intelligence officer, like the people with really decoding ciphers and figuring out when we were in the midst of being attacked and stop it without anyone else knowing. And a lot of lawyers, they were recruiting lawyers for that, because that type of work is, you can't train for it in the traditional way where you go to training school for a trade, right? Because part of the way that terrorist attacks can happen is that they think in ways that are just not the rote methods of attacking. And so you need people who are able to think outside the box and use their brain in ways that are not common in order to figure these things out. And so I thought that was really cool. But
And you need lawyers and everything. I mean, everything has a legal department. So you want to work on movies, but you're ugly and not talented? Well, you can be a lawyer for a studio, right? I mean, you can always be a lawyer. And you can be the lawyer who says yes, we just did this thing. I didn't talk about it because I'm not supposed to, because what the lawyer said. But in the process of doing this thing, they made us cover up all our logos. And it's like, why are we having to do this? Because some stupid lawyer said so. Be the lawyer who says, that's stupid, don't do that, right? Or be the lawyer who says, yeah, you can use that. You can be like a lawyer who's excited.
I'm just going to say, maybe get hired.
No, don't be. This is the problem. Bad lawyers are a problem, because bad lawyers take the easiest route, and the easiest route is always no. Exactly. Say yes. And I'm a yes guy. You come to me in my office and you ask, you want to do something cool? I'm going to say yes. And there are other lawyers who will be like, oh no, that could affect the office in some way. It's like, I'm not going to do that. I'm going to say, yeah, you go for that. You do that, right? Be
So the
somebody who
cool
says
thing
yes.
is you can be on the cutting edge of technology, right? So for example, my brother works with drones, and obviously there's a lot of laws and regulations, and people don't understand, are drones going to attack us, or is it too much AI, X, Y, and Z? And so there's a lot of legal questions around it. And so his lawyers are certainly the ones that try to get to yes, because the default of people on the Hill in Congress are just no to new things. Drones are just going to cause mass chaos and bombs. And his legal department is trying to get him to say yes. And there obviously is a path to yes. It's but how do you thread that needle? And it takes very creative thinking to do stuff like that. So truly you could do anything with a JD. And there is
anything.
A legal aspect to everything, because we are an incredibly litigious society.
Exactly. So yeah, so the answer is anything you want to do. You can be a spy, you can make movies, you could work for NASA,
you can be an artist. I had I've said this before, one of my classmates who's a lawyer, he was a violin maker, and still is a violin maker, one of the best.
I didn't use his JD for that, but
I don't know that he needed a JD, but it's a pretty cool, on his business card. It's pretty cool.
So there you go. Answer to questions, anything and everything.
Indeed.
Go be
Okay. Well, thank you guys for following along for one of these nerdy episodes. You guys seem to like them. We certainly do, as you can tell with our excited tones. But if you have questions, as I'm sure you do, because we didn't necessarily answer anything, because we don't actually know what the Supreme Court will do. These are our best pontifications, but at least it helps you be able to talk about it somewhat intelligently or decipher what you're hearing in the oral arguments. Let us know what you'd like to listen to us talk about, rant about, what have you. You can reach us at prosecutorspod@gmail.com, reach us on social media. And until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. don't know which direction I'm gonna go. There's a few jokes happening in my head in real time. Okay. These jokes are just happening in my head and nobody can hear them.
You should pick one and go with it.
I should. Okay. I don't know why I can't. This isn't even going to be funny. We're just going to go with this one. Okay. Welcome back to the... don't mess me up. Welcome back to the legal... This is going to be great tonight, guys.
This summer, Pluto TV is exploding with thousands of free movies. Summer of Cinema is here. Feel the explosive action all summer long with movies like Gladiator, Mission Impossible, Beverly Hills Cop, Good Burger, and Transformers: Dark of the Moon. Bring the action with you and stream for free from all your favorite devices. Pluto TV. Stream now. Pay never.